U.S. Immigration Attorney Sharifa Tharpe. I have a good topic for you today, and I'm looking forward to receiving your questions. You can ask any immigration related questions that you'd like. So, as soon as you join me on this live, go ahead, put your questions in the comments, and I'll be more than happy to answer your questions as soon as I finish talking about what I have to discuss. So, I'm going to be talking about what you should be doing if you get a request for evidence or a NOID. So, in our world, we call a NOID a notice of intent to deny. So, two very serious types of notifications that you need to make sure you pay special close attention to so that you don't get a denial. Because usually an RFE or a NOID, it sometimes is you, depending on what they're asking for, it's your last chance to make things right and to change your case from a possible denial to an approval. Now, the first thing I want to announce here is that, during COVID, the USCIS had issued certain flexible deadlines and extensions to respond to requests for evidence, NOIDs, and appeals. And that with that extension and the flexible deadlines, it allowed individuals to respond to requests for evidence or respond to NOIDs and as to submit appeals 60 days. It would give an additional 6 days on top of the deadline date to be able to submit the responses. So it was, of course, it was meant to try to make up for any complications and delays related to the pandemic, but it also gave individuals a longer time to be able to respond to these, to get the help they needed to respond to these, and to turn their cases around. So unfortunately, today, March 23rd, they're ending that. So they will no longer have these flexible dates. So when you get a request for evidence or a NOID, just know that the deadline that's stated in that document is applicable. There's no longer a 60-day extension on that date, on that deadline date. If you don't respond by the deadline, then they usually can reserve the right to deny your application for failure to submit the requested documentation. So you don't want to miss out on responding to a request for evidence or a NOID. These types of documents, they usually give you the time to respond to them, and so it does create complications when you miss the deadline. And if there's no good reason for missing the deadline, it can complicate your case. It means that you would either have to refile or appeal. So it causes a lot of hassle because it's expensive. You have to pay a lot of fees, and it's expensive time wise as well, because you end up spending all of this time waiting for a result just to get a denial. So you don't want to miss the deadline here. With a request for evidence and NOIDs, so remember the NOID is a notice of intent to deny, it's usually 30 days. So 30 days after the decision date or the date of the notice. It's not 30 days from when you received it. If it's sent by mail, you have an additional 3 days onto that 30 days. But 30 days is basically the standard here. So it's not, and if they have any other deadline, by the way, they'll go ahead and put it in the notice. So if they have a deadline that's different from the 30-day deadline, their standard deadline, they'll let you know in the notice. So you have to pay attention to that date. Now, when you receive a request for evidence, obviously, when I am submitting a response to the request for evidence, my client who made some of them were not my clients before, and when what the first thing they did for them to be my client was they called me for help. So that's the first thing you're going to want to make sure to do. Don't waste any time, because you're on a limited timeline. And so it's very hard. So if for example I get a consultation to speak with an individual in a consultation about their request for evidence, and the request for evidence is due tomorrow, it's and say it's approaching the end of the day, it's pretty much impossible to go ahead and be able to meet the deadline on such a short notice. So you have to keep that in mind, that you have, if you're going to go ahead and call for help, which in this case I highly recommend you do, because if you approach this incorrectly, it can be detrimental to your case. But if you are going to seek assistance for your case, give the attorney sufficient time to review everything and to be able to work with you to get a response in. Usually, when an individual hires me to respond to a request for evidence or a notice of intent to deny, we have to go through a process where we have to sign special forms to authorize me to represent them before the immigration service, depending on the complexity of it. I myself have to do legal research in order to consult the right authorities, case law, rules, regulations, statutes, to be able to respond to a request for evidence. And so it is time consuming. It does require, it's not just some, in some cases it doesn't just require a letter, a one-page letter back to the USCIS. Sometimes it requires extensive documentation, extensive legal research, the drafting of a brief or legal letter with additional evidence to be able to submit a good response to a request for evidence or response to a NOID. So if you're going to go ahead and get help, which I highly recommend, make sure you do it right away. It's urgent. Treat this with urgency. Give the attorney sufficient time to respond to that. Keeping the deadline, always keeping that deadline in mind. Now, don't panic if you see a request for evidence. Sometimes it does invoke a lot of anxiety. But requests for evidence can range from something that's very simple to more complex issues, right? So because you've been issued a request for evidence, it does not mean that you're going to get some detrimental requests or information in the mail. Sometimes what you get is, hey, we need the affidavit of support. Sometimes if they're going to waive the interview, they will ask for the medical examination. And so it will be issued in the form of a request for evidence, so that you can just do the medical examination and then send it in, and that would be able to meet the requirements of the request for evidence. Now, I send these requests on behalf of my clients. I don't make my clients give them anything and then tell them to mail it back. I'm the one that manages it for my clients. However, if you are dealing with your own request for evidence, which I don't recommend, but if you do find yourself in a situation where, say, you're on a super tight deadline, you couldn't get help for it, you need to respond. You have to make sure you follow the instructions in the request for evidence or the NOID carefully. They towards the end of the letter, so read every single detail in your request for evidence or NOID. Towards the end of the letter, they will put in the NOID where you need to send your response and how you need to send your response. Follow those instructions so that they can sufficiently log that they received it, and that they received your NOID or your request for evidence, and that it doesn't get lost. Because if it goes to the wrong place and the right people don't get it, guess what happens? It means that you will not. They will have that they never received your request for evidence, and then you could potentially get a denial, which, it is a bureaucracy, and just to fix a situation like that gets a lot more complex. So make sure that you follow all the instructions. Now, I have turned around notice of intent to deny for my clients. So if you do get a notice of intent to deny, whether your case can be turned around, of course, is going to depend on what's going on in your case, but it can happen where you can get this. The notice of intent to deny is basically the USCIS saying, hey, giving you a heads up, we plan to deny your application unless you can convince us otherwise. So, in summary, that's what they mean. And then they'll tell you what the issues are that they're having some doubts on and why they feel like you're not eligible for whatever you're applying for. And then it really is up to you and your attorney to respond. Don't give up. This is not an official denial. And we have submitted evidence and we've gotten it turned around from a notice of intent to deny to an approval. But you have to, usually in cases like this, especially where it's very complex, you want to make sure that you get the help because, for example, in the cases where I have responded to these, I've had that legal knowledge to be able to point out why my clients do qualify, even though they say they don't. And oftentimes they do agree with me and go ahead and turn it into an approval. So don't give up. Don't try to go refile a new application. Tackle the notice of intent to deny, but first make sure you get assistance. Thanks so much for the love. I appreciate it. Now I'm going to go to questions. I've told you exactly how to look at the request for evidence. Request for evidence can vary. It's not all the same. So what you're going to put in the response is going to depend on what's in that. It can be simple, can turn out complex. Notice of intent to deny, same thing. It could be, hey, you never submitted this document. Say you never submitted your birth certificate. So we're going to go ahead and deny you until you send us the birth certificate. It can be, even though it's not often that that happens, but NOIDs can be as simple as that too. So it can differ, and whether or not you're going to need that assistance is going to come down to the complexity of your situation. But I often say this, right? Why risk it? Don't assume that your case is simple. Don't assume that your application is simple. Why would you risk your future by making an assumption like this? And this is where I see a lot of people go down rabbit holes and get lost in the process, and things get complex. And usually their explanation for not getting help to begin with was, I really thought this was going to be simple. I never knew it was going to be like this. And nobody ever knows it's going to be like that until it happens. So take it from me, get the assistance you need to do it right. All right, so I'm going to answer questions. Now, if you'd like to get in touch with me, go to the link in the profile, and as soon as you get to the page, there are a number of buttons to go ahead and schedule your appointment. You can schedule your own appointment online. You can call the number, it's a 24/7 number. Our office hours are 8:30 to 6:30. If you are thinking about getting assistance from me 3 in the morning, go ahead. Don't hesitate to call, and there will be a staff member there to assist you. And then the scheduling coordinator will get back to you on the next business day. So if you call on a Saturday, you're going to hear from the scheduling coordinator on Monday to be able to help you to schedule. But you don't have to wait. You can schedule your own appointment as well. So on Instagram, go to the link in the profile. On YouTube, go to the description of the video. You'll see the link where you can access the link to schedule your own appointment, the website where you'll see the phone number. Phone numbers are also all over my videos. It's on the YouTube live right now going across the screen. And if you go to any of my videos on Instagram, you'll see it there. And also on Facebook and Twitch, you'll see it in the description of the video and going across the screen. So many ways to get in touch with me. It's very easy. to get in touch with me and get on board with the firm to get the assistance you need. All right. So, hi there. Good afternoon. Marriage to US, I have asylum case. I'm going to the court date. My judge is dismissed my case because I have a VAWA case. Can I travel to my home country? So I wouldn't be able to tell you whether or not you can travel, right? Just because the risk factors here, there are a number of things going on. You had an asylum case that was in court, which means that you were going through removal proceedings before the judge dismissed the case. And then you have VAWA pending. And then I don't know if you remarried, but that could be a problem for your VAWA case. But if the VAWA is related to the US citizen, then okay. But we'd have to look at what's going on in your background, what happened for you to end up in the deportation proceedings, and then advise you as to whether you can travel. Of course, that's what I do for my existing clients is I advise them as to how to approach travel. And I do this on a case-by-case basis. Just because my clients get a travel document, it does not mean that I tell them go right on ahead and travel, because I also want to make sure that they don't have any additional risk factors that can affect their entry back into the U.S. And then keep in mind that you ask if you can travel. Another thing is you have to have a travel document at a minimum, a travel document to be able to re-enter the United States. All right. Hang tight on Instagram while I go through the questions. I have a 2-year green card. My husband and I will get a divorce because it's not working out. Will it be hard to get the 10-year on your own? So it's not a matter of it being harder. It's the same process, right? Going to do it on your own uh, versus doing it with a spouse. It's what the question should be is, do you qualify to do that? Because it will be hard if at the end of it all you don't qualify to apply on your own. But the good news is that when you are getting a divorce, the divorce decree, along with additional evidence in the last 2 years before your card expired, showing that your marriage was bona fide, usually means that you can qualify for a waiver to apply on your own. So it's not right now. The entire process is backed up, whether you're applying with your spouse or whether you're applying on your own. However, you want to make sure that if you're applying for the waiver, you do qualify for it. It doesn't get harder though, because you're applying without the spouse. That alone isn't going to make it harder. Great questions. You're welcome, Malkit. Do you have to pay to get the green card? So, yeah, so you do have to do you have to pay some big money, like pay $1 million to get the green card? There's what's called the investment based green card, so the EB-5 green card, where if you invest a certain amount of money into a business here, you have to meet certain requirements, strict requirements, you can obtain permanent residence that way. Otherwise, everybody has to pay for the green card through filing fees. So there are filing fees that are charged just depending on how the avenue you take to get to the green card. And that varies depending on what type of process you're going. All right, keep those questions coming. These are all great questions. So how long does it take for underage kids paperwork to come through? So at this time, if you're under 21, So those are considered kids in immigration. It is moving faster for the kids that are applying directly through their permanent resident parents or their US citizen parents who are under 21. And so, if they're outside of the country, you're looking at an 18-month to 2-year process. If they're in the country, you could be looking at 6 months to a year to get through if you're under 21. However, if you're 21 or over, that's a whole other ball game. Could be 5 to 7 years. Does the U.S. allow you to get a work permit after you finish your studies? So yes, you do get what is called OPT. So a year after you graduate, there is an OPT to practice, to work in your field here to get some, practical experience after your studies. So that's a year, and then there's another additional extension for STEM fields that you can get as well. All right, so I don't see any more questions. You can go ahead, last chance to put those questions in the comments, and I will answer those questions as they come in. So put those questions in the comments, and as long as I'm here, I'm going to answer those questions for you. So, since that there was that question to about the 2 year, going from the 2 year to the 10 year without the spouse, I want to bring this up because, another troubling question or another troubling issue that I've seen is where, say, the spouses will say things like, if I can't get the green card for you, the 10 year, you're never going to get it. So you need to stay with me, or you need to do what I say. And just know that that's not the case. You have your 2 year, and if your spouse is mistreating you, or if you end up getting divorced, you can still apply on your own to get the 10 year. Just because you are now divorced or separated from the spouse does not mean that now you've lost your chance at getting the 10 year and you have to go back home. So there is the option to still go from the 2 year to the 10 year without the spouse. Now, the option that we choose is going to come down to really specific facts, and that's where the consultation is going to be very important for us to determine the best approach here. But just know that you can have don't allow someone to take away your power by telling you that you have to stay with them, because if you don't, you're not going to get the 10 year. That's not true. And don't get pack up your stuff and get ready to go back home because now you're separated or divorced from the spouse. You can stay here, build a life here, get your citizenship here, even after leaving or divorcing a US citizen or permanent resident spouse. All right, so I see some here. What does it mean when USCIS close a green card case without an interview date? So if they close it, hopefully you got the green card. But it just depends. Usually you get a decision and you'll be aware of why they close it. If you're seeing that they close something and you haven't received any notifications, it's time to get in touch with them. How long does it take to get your physical green card after you get the 485 approval letter? So I've seen a week or two afterwards. It could be months though, just depending on how backed up they are. Does that ultimately lead to getting a green card? I'm sorry, successful. Okay, so no, going from being a student to having your green card is not a direct path. You have to usually find other options like an employer to sponsor you, or if you have other family members or a spouse who can do it too, that could work. What would cause a process to take longer than 6 to 18 months for underage child? So delays, all sorts of things, delays, errors in your application, things of that nature. Can you be determined on? I'm not sure what you mean. Can you be determined on a biometric asylum case? Can you rephrase that so I can understand what your question is? Hi there, Darius. It's nice to see you. Thanks for joining us. All right, so I don't see any more questions coming in, so I'm going to go ahead and head out. Thanks again for joining me. I will be back tomorrow and we'll talk about something else. And you can, if you think of any questions, okay, I see that question now. It makes sense now. Can you be detained on a biometrics asylum case? It is rare, right? In that the purpose of the biometrics is not to detain you, to do any kind of immigration enforcement activities. However, there is always a risk, just depending on what's going on with you. Um, Things can change, right? Even for your immigration matter. If, for example, they now want to detain you because something has changed in your background, if there's an arrest, if there is something that now makes them feel like you're a flight risk, then at that point they can always set it up to detain you in that setting, even though that's not the purpose of it. If you're here and you applied for asylum, you're undocumented, you haven't committed any crimes, you've never gotten a notice to appear, you've never been issued a deportation order, you're not wanted by the police, then I would not be worried about being detained at the biometrics appointment. Right, because that is rare and that is not the purpose. You should certainly attend. And keep in mind, though, that I'm not your attorney and I'm not giving personalized legal advice. So if you are worried about being detained, this is where you should make sure that you talk to an attorney, because speaking to an attorney the attorney, such as myself, would be able to evaluate what your circumstances are and advise accordingly. However, based on my experience with my clients, we've never had an issue like that where just because they're undocumented here, there means they're going to be detained, right? There has to be some additional issues going on, a threat to national security, maybe something of that nature for them to go to that extent to detain you. And then keep in mind that they have, expressed they know the policy, know and approach the policy where they're not grabbing people and detaining them just because you're here without status. There has to be something more like a national security threat, a threat to public safety, or if there's some grievous crime, or you're wanted, you're wanted by law enforcement. Those would be reasons that one would be detained. All right. So thanks again, everyone, for your time. I'll be back tomorrow. So think of those questions and just go ahead and put those questions in the comments. You can ask me anything that's immigration related. I'll be happy to answer it. In the meantime, if you want personalized legal advice, go to the link in the profile. You'll see everything that you need to there. Um, Now, I see one more question that I can't resist here. Are you permanently banned from the country if you overstayed your 6 months? No. But here's how this works, right? If you overstayed, if you stayed over the time that you were supposed to by 6 months, and then you leave the country, you are now barred because you're accruing unlawful presence. You're now barred for 3 years. When you go ahead and you overstay a year or more, then that turns into a 10-year bar if you leave the country. Now, where the permanent bar comes in is where you were here, you overstayed by a year, you accrued unlawful presence, left the country, and then snuck back into the country. Then that's a permanent ban. If you've been deported and then you came back in after the deportation without permission, without inspection, that also causes a permanent bar. Which, let me just mention this here: VAWA, the T visa, those are two forms of relief that you'll hear me talk about often, does cure those types of bars as well. So if you do qualify for those, it can help you to fix your situation. Now, if you're already here, now, Raheem, make sure you get legal advice because now you're getting really specific and more, and it seems like you're getting more complex. But keep in mind that once you've overstayed, your visa is automatically invalid. You cannot leave the country and then travel back on that visa. They will flag you and cancel that visa for you. It's been 13 months, file I-29F. Should I continue to wait? So if you are, keep in mind that if you are filing for the fiance visa, you're trying to get your fiance here, and then you go ahead and then you refile it as a married couple, you're starting from scratch again. They're not going to pick off where they left off. So that's where I tell people, if you're trying to choose between the fiance visa and the marriage base, you have to choose now. Because if you're halfway through the fiance visa, and then you decide to get married, you're no longer no longer eligible for the fiance visa. You have to start from scratch with a marriage base. So right now, if your spouse, if your fiance who will become your spouse is outside of the country, for marriage base, you're looking at 18 to 24 months, unless they speed up the processing, but that's the timeline I'm seeing. So you would be adding that processing time. So I can't tell you what to do, but it sounds like you're 13 months invested in the I-129F. Sibling petitions take 14 years. All right, so that's going to be it for me. Have a good one, everyone. I'll see you tomorrow. Join me tomorrow and come with your questions. All right, bye-bye.